We have Lamonte, there you are, Ms. Butler. All right, he's present in custody with Ms. Connolly. We have observers.
We do, Your Honor. Ashley Sisolak standing in for Mr. Meningo on behalf of Raven Queen.
Good morning again, Your Honor. Tom Erickson, also on behalf of Raven Queen.
All right, and you guys are just seeing how this proceeds. I don't know, was it joined or filed? I don't even know that it's joined or applies here. These are individual devices with personal expectation, privacy.
Sure.
The argument,
We did file a joint, Your Honor.
right.
To the
I'm not
extent
sure
that
what
it
that
applies.
entails in something like this, but okay. So as it applies to Mr. Butler's phone, I guess the joint, what is recovered on that that could be used against their clients, but then they don't have standing. I don't know. I don't know how it works
They
here.
don't have standing to join a device that they don't have any, because that's really interesting. And they made no arguments to suggest that they did, other than they're joining his motion. So to me, it's just, they're here in support of Mr. Butler's position that it should be suppressed against that.
We can address that further at the end if you guys would like. Okay. So Ms. Connolly, this is your motion regarding your client's cell phone. First issue regarding standing. Let's start with that.
Yes, Judge. If you look at the Riley case, and I say Riley versus California, the Supreme Court made it clear that an individual has a right to privacy in a cellular phone.
Yes.
The state has argued that my client abandoned the phone, therefore he lost his right to privacy. However, in order for there to be an abandonment requires an objective manifestation that the owner intended to relinquish any expectation of privacy. What he did was, what he allegedly did was hide the phone underneath the mattress in the Mesa residence. So that clearly wasn't a objective manifestation that he intended to relinquish any expectation of privacy. Now, regarding the phone being damaged, I would present that reflects that he did not want anybody to see inside his phone. He was maintaining his right to privacy. Also, the courts have indicated not to conflate obstruction attempts with privacy. So maybe they could have an argument. He tried obstruction by trying to destroy it, but that does not destroy his right to privacy. It wasn't an abandonment.
And so that Basinski case is the one that you cited for that proposition. And that the case, the factual situation there was that the federal court really focused on the fact that he had given it to this trusted friend. For Mr. Basinski, given the briefcase that he then said destroy to a trusted friend for safekeeping, and saying that he's not inviting the world to rummage through it. In fact, he's saying dispose of it so no one will ever see it. This isn't being given to anyone trusted necessarily. So how are those facts similar enough to say that this is, you know, that falls under that?
I think when you give your phone to a third person, then you don't really have a reasonable expectation that person's going to maintain privacy. In this case, it's not a situation where he gave the phone to somebody and said, keep this. He hid it underneath a mattress. That's the difference between this case and the cases that are relied upon by the state. In that case, and I think the Basinski case, the phone was given to somebody else. So if my client had given the phone to somebody else, I wouldn't be making this particular argument, but he didn't. He
But Basinski is essentially saying by giving it to somebody else who's trusted, that shows that you want to keep your possessory interest in it, because you're not just giving it to some schmo on the street, or you're not abandoning it in the garbage. So it kind of really turns on the trusted friend angle there.
Well, I think would that be objectively reasonable to expect that somebody else is going to maintain your phone versus hiding it? Clearly, I mean, I think if you gave it to a trusted friend, then that may be a different kind of argument. Then we'd be arguing that issue. But in this case, he didn't give it to his friend. He hid it under a mattress, which I think is significantly different to giving it to a friend.
And that, remind me who the Palm Mesa house belongs to?
We don't know who the Palm Mesa house belongs to, which is one of the other issues that I raised. I mean, the state spends pages and pages talking about all the evidence in this case. Most of that evidence was obtained after the search of all the phones. What happened was, I think the police were trailing one of the suspects to that residence and knew that at least one or several suspects were in that residence. So then they got a warrant to search the residence. But the problem with the warrant, from my client's perspective, is they searched every phone in the residence. Not just the ones, and in their search warrant, they had provided details. Details of phone number, phone logs, GPS data to 3 of the defendants, but there was nothing in there pertaining to my client. So essentially you have them going into a house, they don't know whose house it is, and searching every phone in there.
But
Now,
then
this-
going back to the threshold issue of standing is if you are leaving an object in in a house, you don't know who it belongs to with, how does that give you a subjective or any sort of belief that you're ever going to get that item back?
Well, I mean, my client may have known who the house belonged to, but the state didn't know whose house. It had been Wade and Queen's house, or it had been one of the co-defendants' houses. That may be a little different. There was some nexus between that residence and the conspiracy. But the only lodging that had a nexus to the conspiracy was the Cancun. The Cancun Hotel is apparently is where they're accused of doing all the planning and staying. There's the Mesa residence doesn't come into this until the police believe suspects are in there. And they ask them to come out, they wait an hour, and then the suspects all come out. And then they go in with that broad warrant with no nexus whatsoever. That my client's phone may potentially be in there. All the talk was about the other suspects' phones. What they did was they searched all the phones and then they got the probable cause after the fact. Oh, look at all this that was on his phone, but they didn't have anything prior to executing the search warrant. And the affidavit didn't establish specific probable cause for him or his phone. Now, the other 3, who all the details were in, yes, that would apply, but for my client, it doesn't. They have to have specific device probable cause. They didn't have that for him. I think the problem is that they seized all the phones, did the extractions, and then they figured out which phone belonged to who, which is improper under the Fourth Amendment. And the Riley case, I think, is really important because the Supreme Court emphasized that cell phones contain what the court called the privacies of life, and that digital searches require careful adherence to the Fourth Amendment because basically our lives are on our phones nowadays. So what the police did was they searched a phone, determined ownership afterwards. That's specifically the kind of broad digital search that Riley warned against. And I don't think the good faith exception would apply in this case because the police they had enough probable cause to search the phones of 3 other suspects. They had all that detailed information about their phones, the phone numbers, their GPS. So they knew that they needed to have device-specific probable cause. But they didn't do that for my client. So they knew it was required, but they just didn't do it, or they didn't have the information, or they just didn't have probable cause. Therefore, the good faith exception does not cure the problem because they should have known better.
But how is this warrant so lacking in indicia of probable causes to render official belief in its existence unreasonable or so facially deficient it couldn't reasonably be presumed valid by the serving officers?
Because they knew they had all the detailed information about the other 3 phones. So they had put that in there. They obviously knew they needed that to search those 3 phones. Or they wouldn't have put it in there, but they didn't have that from my client's phone. So they didn't know which phone belonged to the 3 people that they had sufficient probable cause. And I acknowledged that in my motion. They had probable cause for 3 of the phones.
Right.
But for his, there was nothing in there other than that he was in that residence and there's no nexus between that residence and the conspiracy or any of the crimes, nothing.
All right, let's start with standing.
So Judge, I think we have to take particular issue with this argument that the defense is putting forward that his efforts to destroy the phone show that he was trying to maintain some privacy interest in it. When you're trying to destroy property like a cell phone, he's trying to rid himself of any possessory interest in the device itself or its contents. And we know why, because it contains incriminating evidence. I mean, that phone contains a significant amount of evidence of him and his co-conspirators.
Who does Paul Mesa belong to?
It's an Airbnb. It doesn't belong to any of them. They all reside in Pelican. So it's not their residence. And when you look at you have to look at it, right? The facts and circumstances surrounding the recovery of the device. You have the defendant and his co-conspirators all coming back to Vegas, all in the same house. And they have a surrounding call out by the police. They then say, we'll be right out. They take an hour before they do, during which time we know they were destroying cell phones. We provided the court with pictures of the many cell phones that were destroyed, as well as attempting to destroy Mr. Butler's cell phone, hiding contraband like his cell phone underneath a mattress before he leaves the residence, or firearms up in an attic. And then finally leaving all of the property behind to come surrender to law enforcement.
So the federal lines of cases have established three general types of abandonment. This first is the presence of a fleeing defendant who relinquishes an object to make his flight easier, or because discarding the item may make it easier for him to later claim that he never possessed it. Second, or in that situation, it's a disposal of the property in the location that affords easy access to the public, so a reasonable person will believe that the defendant's possessory interest in the property is so eroded anyone has a right to retrieve it. The second are the garbage cases where the defendant throws something out that is, and it's so readily accessible to the public, so that obviously shows directly abandonment by throwing something in the garbage. And then finally, there's the situation where defendant is caught sort of red-handed with or near a container or contraband, and then he denies that the container or the contents are his. Where would you say that this falls in those three categories, or is this something else?
I think it squarely falls in the first two categories, because first of all, when you're talking about flight, right, they have nowhere to run. There's a surrounding call out. The notion of abandoning property in response to imminent law enforcement action is exactly what he did here. He attempts to destroy the phone, then he hides it, and he walks out of the residence without it on him, leaving it in a residence that he does not have any interest or possessory interest in.
But in some way, isn't the hiding and the destruction, and it's similar to the Basinski case, in that he's showing that he's not inviting the world to rummage through that phone. He's saying, dispose of it or get rid of this.
He's not handing it off to someone. I mean, first of all, we provided the Ninth Circuit Sella case where they said attempts to destroy, even if you don't follow through with the destruction or it's not successful, constitute abandonment. So I'm not sure how that squares away with the case Your Honor is citing. But I mean, he is attempting to destroy the phone, relinquishing any privacy interest in it because he doesn't want what's contained in it to be found on or with him. So he has not, it's not like he wants to go back and get his phone at some later date. He wants it to be completely and the contents of his phone, right, which is what we're searching. He wants that gone, disappear, because it contains incriminating evidence. So just by the mere act of attempting to destroy it, hiding it from law enforcement, and then leaving the house without it, so that when he
In an
is
Airbnb that doesn't have possessory interest of any
so
of the
that when he is
co-defendants to be
apprehended,
retained.
he does not have his cell phone on him, so it can be acquired. All show intent to abandon. I think it's similar as well to throwing something in the trash can. You're getting rid of evidence that you have no more possessory interest in, that you know will then be picked up by trash services and subsequently destroyed. I mean, that's what we're talking about here. Is there's not three specific categories. It's a question of intent inferred from the totality of the circumstance. We provided the court with case law about people asking third parties to destroy, people who abandon their property inside like walls inside homes that they then exit and leave. Leaving it item in a trash can in a hotel room when you leave, and then all the other cases Your Honor cited to. So, I mean, when you look at the facts and circumstances, it is very clear he did not have any interest to go back and obtain that phone to get what was in it, because he's attempting to destroy it because he knows in response to imminent law enforcement action that they're about to come in, take him into custody, and potentially search these phones which contain incriminating evidence. And we also cited to case law that says when a property is abandoned directly in response because you're about to be arrested, that still constitute abandonment. It's not like, oh, I want to go back and get it after this. They're trying to get rid of or distance themselves from a particular item of incriminating evidence.
Okay. Did you want to argue further if the court finds standing?
I'll submit on what we filed in our opposition. I think it's pretty thorough, Judge.
Okay, Ms. Connolly.
Judge, responding to that argument, if you look at the Sella case is the one that the state relied upon. And it stands for the proposition that where a defendant allows a third party to exercise actual or apparent control over his property, he is considered to have assumed the risk that the third party might permit access to others, including government agents. He didn't do that in this case. And then you go to Basinski. Intent to destroy does not equal intent to relinquish. And there's also the number of federal cases that were cited by the state. And they stand for the proposition that where there's probable cause to search a particular device for digital evidence, officers may conduct a comprehensive search because digital files are not easily organized. That principle presupposes there was probable cause tied to the device in the first place. None of their cases applied to the situation that we have here, where there is no probable cause as to that specific device. Now, for the other phones in there, like I indicated previously, they had phone numbers, they had a lot of data pertaining to those particular phones. My client's phone was nothing, and again, in their response, they say that this Mesa residence was the hub of the conspiracy. It wasn't. Cancun was the hub of the conspiracy, and maybe this property being found in the Cancun would be a different story, but that's not the situation.
Judge, do you want me to touch on any of the acts on the warrant outside of what we argued in our opposition?
No. All right, regarding the standing issue, a defendant must first establish standing by demonstrating a legitimate expectation of privacy in the item that's being searched. Katz versus United States. Voluntarily abandoned property is not protected by the Fourth Amendment because a person who abandons property relinquishes any reasonable expectation of privacy in it. Abandonment is determined by objective manifestations of intent based on the totality of the circumstances. This was a 1-hour police standoff at the Palm Mesa residence, which is an Airbnb that no one in this case owned or really had a subjective expectation they would be able to return to. The defendants intentionally destroyed multiple cell phones and other incriminating evidence before surrendering to law enforcement. Butler's phone was recovered in a damaged condition with other dismantled evidence, and the forensic report indicates incriminating messages were deleted during the standoff. Ultimately, this is disposal of the property in a location that does afford access to the public because this is an Airbnb with no reasonable expectation of anyone in that group being able to return to it, so we could ever retrieve that. And a reasonable person would believe that the possessory interest in the property is so eroded that at that point, anyone who finds it in that Airbnb has a right to retrieve it. If it wasn't the police, it would have been the next person who would have rented that Airbnb. Additionally, there's an objective intent to relinquish. So overall, under the facts of the Sella case, there's an objective intent to relinquish any reasonable expectation of privacy in the device. In that case, the efforts to destroy evidence constituted abandonment. Ultimately here, I find that Butler abandoned the phone in the house and lacked standing to challenge the search. Assuming arguendo that standing existed and even if there was a deficiency in the search warrant, suppression would be inappropriate under the good faith exception. Evidence obtained in objectively reasonable reliance on a warrant issued by a neutral magistrate is admissible even if the warrant is later found to be defective. Under the Leon case, the warrant here was supported by detailed affidavit, reviewed by prosecutor, approved by a magistrate. The affidavit details a coordinated conspiracy involving violent home invasions and murders, includes surveillance footage, call detail records, GPS data, and communication between co-conspirators, and establishes that cell phones were actively used to plan and execute these crimes. Nothing suggests that it was so lacking in probable cause or so facially deficient that reliance on it would be unreasonable. It's not the extraordinary circumstance described by Leon. So suppression would not serve the deterrent purpose of the exclusionary rule. So the motion to suppress overall is denied. State to prepare the order.
Thank you, Judge.
Thank you, everyone.
Thank you, Anna.
The joinder issue is moved.
Understood.